Education. It's the heartbeat of our communities, the foundation of opportunity. For decades, programs like the Teacher Quality Partnership and Supporting Effective Educator Development have fueled that promise, training teachers, lifting students, and strengthening schools across America. But in the winter of 2025, that promise came to an abrupt end for many schools because of the discriminatory and ideologically based curricula that has infiltrated the educational system. On January 23, 2025, the U.S. Department of Education took action to eliminate harmful diversity, equity, and inclusion initiatives, including references to them in public-facing communication channels and its associated workforce. These actions are in line with President Trump's ongoing commitment to end illegal discrimination and wasteful spending across the federal government. They are the first step in reorienting the agency toward prioritizing meaningful learning ahead of divisive ideology in our schools. Following President Trump's recent executive orders and initial guidance from the Office of Personnel Management, the department removed or archived hundreds of guidance documents, reports, and training materials that include mentions of DEI from its outward-facing communication channels. The department also put employees charged with leading DEI initiatives on paid administrative leave. These review efforts will continue as the department works to end discrimination based on race and the use of harmful race stereotypes, both within the agency and throughout America's education system. On February 5, 2025, a directive from the Acting Secretary of Education shook the system. Over 100 grants, millions of dollars meant for teacher training, were slated for termination. The reason? A claim of policy conflicts, targeting initiatives like diversity, equity, and inclusion. 2 days later, letters went out. Programs in 8 states, including California, faced an abrupt end. The response was swift. 8 states sued, arguing the move was arbitrary, unlawful, a violation of the Administrative Procedure Act. On March 10th, a federal Judge Richard G. Stearns in Massachusetts agreed, issuing a temporary restraining order. It paused the cuts, ordered the funds to flow again. For a moment, hope held firm for the school districts who support discriminatory classroom DEI curricula. But that hope collided with the highest court in the land. On April 4, 2025, the Supreme Court stepped in. In the 5-4 ruling titled Department of Education v. California, they overturned the TRO. The grants could be cut, right now, while the fight plays out in lower courts. This is the story of a battle over proper education, power, and justice. The stakes. To understand what's at stake, let's rewind. Congress created the TQP and SEED programs to tackle a crisis, a shortage of qualified teachers. The goal? Better student outcomes and stronger educators in the classroom. They were 5-year commitments and awarded to schools and universities nationwide. But on February 7th, identical letters landed in inboxes. Each one said the same thing. Your grant's done. Why? Something about DEI initiatives or fraud or department priorities. The directive from the Department of Education warned schools that grants would be terminated if DEI wasn't eliminated across the land in our educational institutions. For states that support discriminatory and corrosive DEI curricula, it was a shock to the system. For the schools that didn't comply with the directive, millions of dollars gone overnight. 8 states, California among them, rushed to court. They argued this wasn't just about money, it was about trust, about the law. The Administrative Procedure Act says agencies can't act on a whim. The district court listened. As the dust settled from the initial rush to court, a new legal front emerged. On April 4, 2025, the United States District Court for the District of Massachusetts received a crucial motion. The case, filed under the title State of California, Commonwealth of Massachusetts, State of New Jersey, State of Colorado, State of Illinois, State of Maryland, State of New York, and State of Wisconsin, versus U.S. Department of Education, Denise Carter, in her official capacity as former Acting Secretary of Education, and Linda McMahon, in her official capacity as Secretary of Education, marked a significant escalation in the legal battle. Plaintiff states filed a motion for leave to submit a supplemental filing in light of the Supreme Court's decision. They respectfully requested permission to submit this filing by no later than Thursday, April 10, 2025, addressing the matters raised by the Supreme Court's decision. The date was April 4, 2025, the same day as the Supreme Court ruling, and the stakes had never been higher. The courtroom was now another battlefield, where states sought to navigate the complex legal landscape and hold the U.S. Department of Education accountable. This motion was more than a mere formality. It represented a strategic move in an ongoing war of legal wits and constitutional interpretation. The nation watched closely as each side prepared for the next round in this high-stakes legal drama. As the legal battles continued, new injunction requests emerged in the aftermath of the Supreme Court ruling. One notable brief, filed on April 4, 2025, in the case State of Washington v. Trump, Western District of Washington, Case No. 225, CV00244, sought an emergency injunction to block specific actions or policies. The exact nature of the request remains unclear in the available context, adding to the growing complexity of the situation. Despite the Supreme Court issuing a stay on April 4, 2024, states weren't backing down, signaling that the fight was far from over. As Margot Cleveland aptly put it, "I smell something fishy. There are no matters to address. SCOTUS state injunctions. Appeal is pending. On March 10, after a 2-hour hearing, U.S. District Judge Myong issued a temporary restraining order. It stopped the terminations cold, forcing the government to keep paying. The TRO would hold for 14 days, then got extended to April 7th. But the department fought back. They asked the court to lift it, then the First Circuit. Both said no, so they turned to the Supreme Court, claiming the judge overstepped. Ordering money payments wasn't her call. It was an emergency, they said. The clock was ticking. On April 4th, the Supreme Court ruled. In an unsigned opinion, they called the TRO a preliminary injunction in disguise, appealable and flawed. They said the APA doesn't let district courts force cash payouts. That's for another court, the Court of Federal Claims. The government, they argued, risked losing millions it couldn't recover. The states, they could fund things themselves, appeal later if they win. The stay was granted. The cuts could resume, pending appeal in the First Circuit. Chief Justice Roberts dissented silently, but two voices rang out louder. Justice Elena Kagan called it a mistake. "The government doesn't even defend these cuts," she wrote. "States are losing teacher training, real harm, while we rush to judge on bare-bones briefs." Justice Ketanji Brown Jackson, with Sonia Sotomayor, went further. "Dozens of programs will be gutted," she warned, quoting the judge. "This devastates schools, students, teachers, against everything Congress wanted. And for what? A risk of funds being spent as promised? It boggles the mind." Jackson saw no emergency. The TRO was days from expiring. Why intervene? She accused the majority of overreach of siding with power over people. Act 4, the fallout. So where are we now? The Supreme Court stay means the terminations are back on. States and schools must scramble if they defy the Department of Education on eliminating DEI in the classroom, or find money, cut the DEI programs, or wait for the First Circuit to weigh in. It also signals that the High Court is potentially inclined to side with Trump in similar pending lawsuits over cancellation of federal grants, contracts, and programs that had been authorized by Congress. The Tucker Act grants the Court of Federal Claims jurisdiction over suits based on any express or implied contract with the United States, the court wrote. For now, the fight's in limbo. The majority sees a legal fix, jurisdiction, procedure. The dissenters see a crisis, DEI indoctrination education curricula gutted. Who's right? That's for the appeal to decide on merit. But one thing's clear, the stakes are more than dollars. They're the future of our classrooms. Pending appeal in the First Circuit 2025. The Supreme Court's stay means that, for now, the Department of Education's termination of the grants is back in effect. If the states and affected grantees are not following an executive order, they are subject to the department's administrative decision to end the grants, which is no longer blocked by the TRO. The stay remains in place pending the disposition of the appeal in the United States Court of Appeals for the First Circuit, and disposition of a petition for a writ of certiorari, if such a writ is timely sought. Following the ruling in Department of Education v. California, Attorney General Pamela Bondi released the following statement. Today marks a significant victory for President Trump and the rule of law. This Supreme Court ruling vindicates what the Department of Justice has been arguing for months. Local district judges do not have the jurisdiction to seize control of taxpayer dollars, force the government to pay out billions, or unilaterally halt President Trump's policy agenda. Department of Justice attorneys will continue fighting to protect the executive branch from gross judicial overreach. Please be sure to hit that subscribe button. For more informed analysis, follow me on X at AndreaFreedom76. All my videos are also uploaded on my YouTube channel at Andrea Schaffer, 5645. Until next time, God bless America.